Someone make it make sense.
Probably a couple.
Hello, everybody, and welcome. We have crazy things happening today in the world of trials. I happened to notice a few hours ago, I suppose it was, during probably Christina Hanley's, or no, I think it was maybe over the lunch break in Karen Reed, or maybe during Christina Hanley's testimony. I was like, oh, let me check the case summary, and I happened to see here a motion to continue. Let me zoom in here a little bit for you guys. Ooh, that's a lot. Not that much. Oof. Okay. So we have, well, first of all, today they had this, where is it? This hearing for, it was closed hearing over Zoom discussing discussion regarding the role of victims. So that happened today, but as of yesterday, but just got posted today. So the day before today's hearing, the defense has filed. So first you have a motion to exceed page limit, and then a motion to continue. And at first I was like, what? Because, and by the way, shout out to Twiz. He got like a whole me giving like a dissertation, if you will, of like realizing what this probably had to do with. And I was like texting it to him, and he was a good sport because I was just like getting all super excited. As I said, I scrolled myself into oblivion with my excitement, because basically this motion is 40 pages long. So clearly it was already in the works. However, so at first I thought to myself, really? They're going to file a motion to continue? And the reason I thought it was odd initially is because they just had this pretrial conference, right? And it seemed like the defense was prepared. I mean, of course, they're always going to say they, would like more time and all the reasons we've heard, right? That's normal. However, it seemed like things were really gearing up to go to trial on schedule in August, right? And they, went through the nitty gritty detail, like including not having the lights on or during opening and closing, and like just the really minute details, caravan at the, for sidebars, and just like painstaking detail, which is what I put in the video description for that reason. And following that, we have this motion to continue. So at first I was like, what? And then I remembered something. And I remembered specifically that we heard it from judge first. So let's take a look real quick here at this. So this is, the fallout, the Dateline fallout, the non-dissemination order. As most of you guys probably know, nothing will piss a court off, and by court, I mean a judge, right? Than violating a court order. When they have a court order, it's an order that they wrote themselves. It's different from like a regular rule or a stat. They take it personally, right? When you violate a court order, you're going to be facing the wrath of name all the things. Name all the things. You will face the wrath of all of them. Even if it might seem a little bit disproportionate, right? Sometimes the orders are not like the be all end all, but the repercussions sure could be, right? And you're usually going to be looking at some sort of sanction. Welcome official. Are you on your other account? You're missing your wrench and all that good stuff. So basically, when I say court order, that includes the non-dissemination order, right? So I'm prefacing that because Judge Hippler is not messing around when it comes to this violation of the non-dissemination order. And I actually already had a stream set up to do like a follow-up of the fallout of that non-dissemination order. And then I was like, oh, wait, we have to do this first because this just happened. So, and speaking of which, just as a little preview, we're going to also hopefully be able to watch Twiz's interview, because he's famous now, as part of that other stream. But anywho, so the court order, right? The non-dissemination order. So what I was thinking about is how, if you're the defense, you're in a really good position to drop. It's like they were waiting. It's like they were just waiting for the right moment to drop this motion to continue. Because again, when you look at it, you're going to see like clearly they had it in the works, but they were waiting. If you look at the video description, I started it out, timing is everything in this case. Timing is everything in this case, right? And boy, oh boy, was this strategic, because you had the Dateline and then the violation of the non-dissemination order. But better yet, you had judge being the first one to say this could disrupt the trial. And so therefore, the defense, it wasn't the defense's idea, right? Like this, you know what I mean? Like, if the defense asks for it, it's going to get denied. But this wasn't their idea. This wasn't, it's like, in other words, it was his idea first. So, oh, you just watched Emily's, was this from the Emily show? Because if so, I actually, we're going to watch that when we do our, like I said, the follow-up of the other live stream I just referenced, where we're going to watch the Twiz interview. We're going to actually watch what she said about that as well. That I already had that planned, and then this took precedent. So yeah, we will watch that too. Oh yeah, I know exactly what you're talking about. Yep, we're going to watch. And I think Lawyer said he's going to be covering stuff out for Kohberger tomorrow. But anywho, so yeah. So yes, but I'm going to show you. I don't tell you guys, I always show you, right? So here we go. So this is what I'm referencing. So this is, again, wait, that's the wrong document. This is the wrong thing. Hold on. Wrong thing. Okay, here we go. This is what I was thinking of. All right, so here we go. I'm going to show you. So here's Judge Hippler, right? Yelling at the state, violating a court order. So again, all of this is working really in favor of the defense, because like I said, you got a violation of a court order. Whichever party does that is going to be facing the wrath of all the things, right? And probably some sort of sanction, because the courts take it personally, right? The second, you have the infraction here, or the violation, done on behalf of the state, right? Which prejudices the defense. But check out what he says. It was his idea first. Check it out. Can I highlight this? Okay, right. All right, so such violations not only undermine the rule of law, potentially by persons charged with upholding it, but also significantly impede the ability to seat an impartial jury, and will likely substantially, increase. Oh my God, what the hell is this nonsense? Go away. Delete. Oh my God, okay. This is just, okay. Can we just go back to highlighting? Okay, let me read it again. Such violations not only undermine the rule of law, potentially by persons charged with upholding it, but also significantly impede the ability to seat an impartial jury, and will likely substantially increase the cost to be borne by the taxpayers of Latah County to prosecute this case by extending the time it will take to seat a jury, and potentially requiring a lengthy period of juror sequestration. And I haven't had a chance to go back and look, but I think he says something to that extent as well in the actual hearing, where basically extending the time and he found it so noteworthy that he changed it from 14 days to 7 days, right? And I'm just looking here. And check this out, just to reiterate, failure to comply with the order could result in civil and criminal consequences. I mean, he's not messing around. Again, you violate a judge's court order and you are in trouble. And that's even more so if you're the state. And that's even more so if that violation has now possibly completely jeopardized the ability to seat a jury. Now, Twiz was asking me some good questions. He was saying, like, well, let me just pull it up. What did he say exactly? Let me find this. Welcome, anyone who's just now getting here. Welcome, Eat Some Z's. Yeah, I mean, Hippler is suggesting it. He's not ordered it in terms of continuing the trial, but he has 100% suggested it. And I actually, like, that registered at the time, but I still wasn't thinking, oh, there will be a subsequent motion to continue. That, anyway, this was, let me see if I can see what Twiz said here. So, again, he was being a good sport. He said, I don't know how it could delay the trial unless they want to find out who leaked it. Waiting longer can't put Dateline back in the bag. And what I was saying is that it's all about the proximity. So it's the proximity of the Dateline episode to trial, because it's just a couple months away, right? And then the proximity of that episode with like a jury pool. So like, because of the way it works with things that are in the media, like the way I was kind of explaining it to him is like, if you've got people that really don't follow this type of stuff, right? Maybe they never even heard of this case, or maybe they heard about it when it first happened, but they completely forgot about it. But then you have a Dateline episode. Then, in other words, and because of the recency, because a lot of times with trials, they'll do this on purpose, right? You'll have like a Netflix series drop right before the trial. And it's because everybody's talking about it, which is why it makes this especially egregious, right? Had this Dateline documentary dropped, I don't know, 6 months ago or a year ago, people that follow this case would have still been like, this still would have been an issue. But the thing is that for people who are potential jurors and aren't following it closely, but yet watch Dateline, right? That might be their exposure to it, right? And so the thing is when it comes to the Dateline thing, like the way I said it to Twiz here, pull it back up, oh my God, was like, you've got like all the different levels here of the taint, as it were, because you've got people that normally maybe weren't so interested or up to speed or whatever will be talking about it, right? So like the general masses, right? So people that either hadn't heard about it or heard about it and forgot. And then but when time goes by, right, they're less likely, they're more likely to forget, and they're also less likely to be exposed because again, this is all, they dropped this on purpose gearing up for trial, right? So right now, the documentary is getting a lot of attention. It's all over the place saying like, quote unquote, new facts. But also not only that, then you've got your secondary media outlets that are saying 10 new facts from the Dateline thing. So like, in other words, you don't even have to see the Dateline thing to still be exposed to the information from the Dateline thing. And then you could even have people like saying to their friend, like, hey, guess what? New facts just came out, blah, 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 right? So, and it's the proximity to having a seated jury. And so what I was thinking is like, I texted Twiz like a whole, I was like thinking, oh my gosh, this could be their ticket for the death penalty. And here's why. Because if you're going to ask for sanctions on the state, right? So I even gave an example, like I'm reading it from the text here. So, Your Honor, we were ready for trial. Like if you're the defense, right? Your Honor, we were ready for trial and we don't want to continue this trial. We've worked hard, we're prepared, we're ready to go, da, da, da. But now we have no choice. And now, due to no fault of our own and because of actions taken by others in violation of Your Honor's order, Bryan Kohberger is unduly prejudiced and having to remain in custody pending trial. And then it could come down to this, because if they have to continue it, right, due to this whole thing, it's going to have to be a substantial period of time to make a difference. Like my estimation would be like at least 6 months, right? So that it gives the time for the air to clear. And I thought about it this way. If it's a choice between continuing the trial for like 6 months or maybe longer, right? Or even continuing it for 1 month, which again wouldn't be enough, but just given how much has already been put into this calendar and all this to make this happen, right? In advance, I think continuing it at all, when you weigh that, if it's like that, Judge Hippler has two choices, like either continue the trial or take the death penalty off the table, because then all the stakes are lowered, right? When you're, and also the whole voir dire process is completely different. And this could, and I wouldn't be surprised if, given the choice between those two, Judge Hippler would choose the latter, because I don't think he wants to continue this trial. But it's clear because he suggested it first before even the defense that he's concerned it will extend the time it will take to seat a jury. So I haven't been looking at the chat because I've been reading all this stuff here that I was sending back and forth and all this. But and Twiz, so Twiz said, if they had evidence, they wouldn't need to taint the jury. And I'm like, Twiz, I know, but not now, not now. This isn't the issue at hand. This isn't the legal issue. Anyway, it's just funny. Is Twiz even here? But anywho, so let me see what you guys are saying in the chat here. But shout out to everyone who's getting here. Oh, you saw Twiz? Where did you see Twiz, official? Yeah, we did. We went over the non-dissemination order with all of its iterations. I can't remember which live stream that was. It might have been the most recent live stream for Kohberger, which isn't, wasn't all that recent, but it was like it was not really planned. Like we were going to be covering a new document or something, and then you guys all wanted to watch the hearing, so we watched the hearing and then we did all the things. But yeah, there was like the amended non-dissemination order, or sorry, there's the original one, then there was like the amended one, then there's the revised amended non-dissemination order, and we did go through those as well. But that's good. I don't know, besides the G's. So the G's were there with their lawyer, you're saying, at the hearing? Oh, interesting. Okay. I guess over Zoom though, right? Yeah. I mean, and it's a big deal, as you guys likely know. For anyone who doesn't know, it is a huge deal. In death penalty cases, there's always a defense attorney is going to do everything they can to save the life of their client should they get convicted. But so rarely does that ever get taken off the table. That's why it was such a big deal when it happened with Lori Dabo. And so, but here, again, given the huge potential, given the reach that Dateline thing will have, and then of course, like I said, your secondary reach because of all the other outlets that are talking about it. Given the proximity to trial, and I think so importantly here, also given the fact that it was in violation of a court order. Like I said, that right there is huge, because the judges, they do not tolerate it. Sanctions for you, all of the sanctions. We've seen this in other trials, even with Karen Reed, we saw, and it was like, remember, and I even referenced, right, sometimes they're disproportionate, where, many of us viewed it as if they didn't violate it at all, but she determined that they did, but the court order wasn't even as nearly big a deal as this is, right? And yet she was talking about completely getting rid of ARCA and whatever it was, all that, when it seemed like everything was up in the air. That was a while ago, but the agents of the state, and that's the other thing, the agents of the state, that's the other thing. If it was the defense, that it would be very different if it was a defense leak, but agents of the state, I mean, everything is in their favor. And they waited for the perfect time to file this motion to continue. I can't wait to go through it, because you guys will see exactly how, like, they had it ready and waiting, and they were waiting for that timing. Timing is everything in this case. I mean, they nailed it, man. Welcome, DSN. Happy to see you. Oh, right. No, Karen Reed doesn't even compare. I'm just referencing because of the whole court order, Judge Bev's court order, right? With the Rule 14 and the discovery, and how she freaked out, and, the whole ARCA thing, right? Just as an example of a recent time where we've seen a judge totally lose it over a violation of their court order and have a disproportionate response for the potential sanctions due to it, right? Which here it's completely warranted, but that's why I'm saying, if you take all of that and you take a huge response for sanctions for violating a court order, when it's obviously, this is like super serious, right? That's why it's like, of all of, like, given that the likelihood of having the death penalty taken off the table is so slim to none, this could be in a situation that warrants it, because that is like the ultimate if you're the defense, apart from having like the case dismissed, but like that's not going to be the thing. And I mean, there's other examples too. In the Casey Anthony trial, with Judge Belvin, he had he had a number of different court orders that he had, they happened pre-trial, right? And I'll tell you what, there's been a number, we haven't even finished it, but there's already were a number of occasions where one time it was the state, another time it was the defense. Whenever they weren't nearly as big of a deal as the non-dissemination order is in this case. They were something minute, right? Like as it pertains to like something specific relating to discovery. It was like a preference of his, right? A preference of his, that type of thing. Not the end all be all, right? But with a whiff of a violation of that court order, because the judges take it personally, it was like the tongue lashing of the century. So I'll just use that as an example instead of Karen Reed. But my point being that for either side to violate a court order, it's a big deal. It's even a bigger deal when it's violating a non-dissemination order, so close to trial. And it's even a bigger deal when it's the state that's doing it. And so I'm saying that if anything could be likely to get the death penalty taken off the table, this is the thing. Unless there's something else that happens that's even worse. But I mean, I think the odds are really good for that. So that's sort of what I was thinking there. By the way, guys, check out those of you guys who are members. We have some updated new emojis. Upon request, we have an updated Hippler with both hands on the face. And shout out to anyone else who's just now getting here. We have a number of new custom emojis. I also have many new sound bites as well from the room, which is some of you guys were there for movie night. And, it's one of my favorite movies, the B movie. So I've got some really great sound clips from that. There's a lot of things. I've been working on a lot of stuff behind the scenes as well, while some of them were arduous and slow testimony was happening for Karen Reed. So I was getting a lot done behind the scenes there. So anyway, okay, so there's that. So, so we looked at the case summary. Okay, so next we're going to look at, of the new filings, first we have motion for leave to exceed page limit. So this is all pretty whatever, but what's interesting here, so to exceed the page limit for their motion to continue and their ex parte supplement to the motion to continue. Ex parte. Interesting. So that'll be just between them and the judge. And then we have the order granting it. He's like, yep, you go ahead. And then the 40-page motion to continue. So here's the reason I was saying that they had this like pretty much established and ready to go, and then they were waiting for the right time. And here's why I say that. So if you look at, this is beautiful. Like I kind of expected it to be just about the Dateline thing, not at all. So I don't know. So the table of contents. So these are the chapters for their grounds. So like if we look at the first one, right? And constitutional rights. Okay, fine. Then we have another one dealing, and we'll go through it, but just to show y'all what I mean here. Then we have myriad constitutional rights. Okay. Then we have in section 3 here, counsel's professional and ethical obligations in a capital case. And again, this is all standard stuff that we've heard them talk about before. It's been brought up in other, situations and other filings and other motions to strike. So these are all standard, par for the course. Okay, so then we have Roman numeral 4. Counsel requires additional time to fulfill the minimum requirements described above. Again, all this is par for the course, standard fare, nothing distinctive here. But then we have Roman numeral 5. A continuance is necessary to remedy the prejudice of highly inflammatory publicity released just weeks before the current trial date, including the recent Dateline special and a forthcoming book. And this is where I'm like, they were waiting to file this, and they added this on, right? Roman numeral 5. And then basically you're going to get to like their conclusions there at the end. So there it is. That's for the third party culprit. Are you saying the ex parte? So I don't, you could be right about that because it doesn't specify. Let me pull it back up. You're right. It doesn't specify. I assumed the exceeding the page limit was in reference to this document, the motion to continue. Where'd it go? But you could be right that it could be the offer of proof and alternate perpetrators. You could be right about that. Needs some Z's. Where'd it go? No, okay. Well, it says, okay, never mind. Take back. Page limit for their motion to continue and their ex parte supplement to the motion to continue. I mean, so I guess technically it could deal with our alternate perpetrators, but I don't know that there would be grounds to continue the trial based on anything related to that, unless like maybe they had an alternate perpetrator who's like fled the country. I mean, I don't know. I don't see how that would be. It's going to be related to, it's a supplement, right? So it's going to be related to the content that we're about to go over in the actual motion to continue. So yeah, ex parte supplement to the motion to continue. Oh, and remember how he referenced in the hearing there's a new administrative order amending local rules of the 4th Judicial District. I wonder. Well, no, that's from 2021. So never mind. That can't be the new administrative order. That has to be something else. Anywho, so yeah, I was thinking initially, I was like, oh yeah, maybe they didn't specify, but because it says motion to continue, I think it's going to be, related to that. I mean, I would expect it to be probably related to what came up in the Dateline thing. So let's do this. Do you guys like the new emojis? Those of you guys who saw them. And some of them, I think I was able to make them bigger, hopefully, as I've gotten better at figuring out what YouTube will allow for like the sizing and whatnot. Yeah, the living document. Yep, exactly. Needs some. I agree. The living document comes to mind. Yep. Because all that is your standard fare, and then the more specific and new stuff is like at the end. Not you're bad. You're good. You're all good. Let me see if I have a new funny thing for that, actually. Actually, none of my new sound clips would be relevant for that. But anywho, all right. So now let's go back up here. All right. Comes now, Bryan through his attorneys of record and hereby respectfully submits the following motion to continue due to the substantial amount of trial, investigation, and preparation still outstanding, as well as recent and forthcoming publicity that is highly prejudicial to the defense. Any conviction and sentence resulting from a capital trial beginning in August of 2025 will be unconstitutionally imposed and therefore vulnerable to reversal on direct or collateral review. Now that's a good, you always want to include that, right? Because that's the thing. It's like if nothing else has succeeded so far, and for any of these death penalty cases, then you want to appeal to the judge, appeal to their fear of being reversed, because that is not good. Judges are always going to avoid reversible error. So that's why that's like buzzwords here. Vulnerable to reversal on direct or collateral review. In making this motion, Mr. Kohberger relies on his right to be free from cruel and unusual punishment, his right to due process, his right to a fair trial, his right to counsel, his right to present a defense, his right to confront witnesses, his right to a fair and reliable sentencing determination, and other rights safeguarded by the 5th, 6th, 8th, and 14th Amendments. The other thing I was going to say too, and it was glossed over sort of in the texts that I was reading that I sent to us earlier, but the other thing too, right, is like if you're the defense, you're like, we didn't want to continue this because if we continue it, the longer it's continued, we have our client is innocent and he's been sitting in custody for however long I'm sure they keep track, and every day that he has to sit, every day longer that he's detained and in custody is, that's unduly prejudicial to him, right? And so because of the state's mess up with this non-dissemination order and then potentially having to continue the trial, now he has to stay in custody for however long, 6 months, whatever. And see, again, that's another thing that you can focus on to work it out, almost like making not really a compromise, but saying, again, you can change this entire dynamic by getting rid of the death penalty, because now everything is completely different in terms of the process for seating a jury, and also the duties required upon counsel, right? Just as you guys know, I don't need to read it. Y'all know how different it is with the death penalty case. So, okay. And I think they would be more than happy to make that. I mean, I can say without any hesitation, they would be much happier to not continue the trial if it meant getting that death penalty taken off the table. All right. So there we go with all these. And then the table of contents. All right. So no, we may not read all of this stuff. That's, again, very par for the course, because a lot of this, what it was, grounds for their different motions to strike the death penalty. And we covered all of those. So we'll just sort of see what is the highlights here until we get to the new stuff here. So, again, so constitutional rights requires counsel more time because it's a death penalty case, counsel requires more time to review discovery, complete investigations, and prepare for trial. They have to weigh the issues against the heightened need for reliability. And then they cite Woodson v. North Carolina, North Carolina. The elevated standard is essential because execution is the most irreversible and profound penalty indeed. And it puts an extraordinary burden upon the court itself and defense counsel to ensure the fairness, accuracy, and reliability of the trial and subsequent sentencing proceeding, because a defendant's life is at stake. Yep. More needs for safeguards. A lot of this, again, these were all cited in their other filings. Because proceeding to a capital trial prematurely is a decision that may lead to the erroneous imposition of the ultimate sanction, this court must consider and assess this motion under a heightened standard of due process. So he has myriad constitutional rights, as we know, which are dependent on counsel having the time and resources to prepare for capital trial. Now, I just want to say, if you're Judge Hippler, you're going to have pushback on this because she just took on another death penalty case, right? This is why I keep saying, like, all of this, fine, but this is not going to persuade him, right? At all, not so far. So, okay, in capital cases, the rights to effective assistance of counsel and a complete defense are amplified. Sixth Amendment. In a capital case, counsel must meet specific professional obligations to be constitutionally effective. The ABA guidelines outline the professional expectations and obligations for counsel in death penalty cases. These guidelines are not merely aspirational. They represent the current consensus on what is necessary for effective representation in capital cases. The Supreme Court has consistently referred to the ABA guidelines to determine the prevailing professional norms for counsel's performance. For example, and we don't need to go through that, well-defined norms, thorough investigation, we know, okay. Good. The Ninth Circuit is not an anomaly. More than 700 capital case opinions cite the ABA guidelines. A footnote. Can we go look? Hyperlink time. Woo! Oh, that's a bummer. 404. So funny, because, like, my brain is like, when I see the number 404, it doesn't matter what the context is. I just think of Rule 404. Anyway, okay, so there's that footnote. He has a right for a meaningful opportunity to present a complete defense. South Carolina case law there. The right to present a meaningful defense must take precedent over any countervailing state evidentiary rules or other procedures that might be acceptable in the context of non-capital criminal cases. And again, South Carolina here. Subsection B. Mr. Kohberger is entitled to an individualized sentencing determination, a constitutional right that is uniquely reserved for defendants facing a death penalty. Because the prosecution is seeking to execute him, Mr. Kohberger also has additional constitutional rights in this proceeding. So to permit individualized consideration of the defendant and the circumstances of the offense, again, citing Woodson. Shout out North Carolina. We insist on individualized consideration as the constitutional requirement in imposing the death sentence, which means we must focus on the relevant facts of the character and record of the individual offender. This evidence includes anything at all from the defendant's life history and cannot be limited. And we've heard them talk about that again. Yep. Okay, subsection C, the right to a qualified expert, two qualified expert assistance as part of the guarantees to effective assistance of counsel and an individualized sentencing proceeding. Given that investigating homicide is uniquely complex and it often involves evidence of many different types, analyzing and interpreting such evidence is impossible without consulting experts. Again, part of the cost, as I keep saying. Hey, DB, welcome. Happy to see you again. Give another footnote. There's Twiz. There he is. Twiz, I've been talking about you. Let's see if this one will work. Oh, good. It did work. So we're not going to look at that now, but I've got that tab opened with this link. So let's DB. So something to consider is that even though Ann Taylor took on another capital case, it's way less relevant on appeal. If anything, she's preserving an ineffective assistance claim for him. Absolutely. 100%. But for anyone who's just now joining us, the thing that I thought stood out to me was that all of these are, again, standard, safeguarding, protecting the appeal. All of this is standard. But the reason they dropped this when they did, in my opinion, is because of the Dateline. And that's what makes this different. Violating that court order, man. So again, for any of you guys who are just now getting here, check out the new custom emojis. Whenever King gets here, he's been asking for his emoji with the fro or whatever, the afro. Anyway, we got that one. We got a lot of different ones here. And also, as I mentioned earlier, we've got some new sound clips too for times when they are appropriate. Okay, so, and we have the double-handed Hippler as well updated. So the right to qualified expert assistance is part of the guarantees to effective assistance of counsel and an individualized sentencing proceeding. Again, a lot of this is, I already scrolled through this. We already talked about this being off the calls. And then we saw that link. Excellent. Citing the ABA guidelines again. As discussed further below in section 3, subsection E, defense counsel cannot know the full range of experts that may be necessary until after the extensive social history investigation has been completed. Both the identification of a mental health professional's necessary area of expertise and the accuracy of the expert's diagnosis is dependent on having accurate and comprehensive social history information. And now we have Roman numeral 3, counsel's professional and ethical obligations in a capital case. Counsel's duty to provide effective assistance of counsel in accordance with the prevailing professional norms. Again, we're all well aware. We've heard them talk about this in the hearings and all the different things. Irrevocable nature of the death penalty. It is quite permanent. That is very true. The ABA guidelines are clear that counsel must thoroughly investigate and challenge every minute piece of the evidence that the state purports to have. Otherwise, you're looking at ineffective assistance of counsel. The defense lawyer's obligation includes not only finding, interviewing, and scrutinizing the backgrounds of potential prosecution witnesses, but also searching for any other potential witnesses who might challenge the prosecution's version of events and subjecting all forensic evidence to rigorous independent scrutiny. They have to investigate all legal claims, even if it's claims that have consistently lost in their jurisdiction. They have to preserve every issue, as we well know. This obligation places a significantly higher burden on defense counsel than in a non-capital case. Again, in the wake of all the things that have just come out with this violation of the non-dissemination order, what you do with this is get rid of the death penalty. I mean, this is their moment. If anything can do it, this recent Dateline thing can do it, in my opinion. This is their time. I mean, because all these things, again, they in every death penalty case, they're going to argue these all along the way. But the difference is now you've got that whole other issue that, just to reiterate, Judge Hippler said it first. Judge Hippler voiced the concern before the defense voiced the concern that it could cause a delay. It's almost like he's going ahead and telling them, giving them permission. I mean, it's pretty awesome, actually. Oh, yeah. It's great. So I'll read the comment on the screen here. DB says, yes, a great use of the moment for AT and team. She affirms she's not scared of seeing who leaked and reframed the issue as a DP and a Brady Giegel issue. Yep. And again, too, right? They're in the perfect position, because when you violate a judge's court order, you face the wrath of all of the things, all the demons, all of the things. You face the wrath of all the things. Speaking of demons and wrath and court orders, just in case there's anyone who has not yet seen the thing I made with Judge Bev's doppelganger, let's just take a quick look at that. Because speaking of all the things, so this is from Judge Bev. This was actually from last Friday, right before she delivered that order regarding the clock drift nonsense. So this is right when she was right about to do that. And then I took a screenshot, and there she is. So that's her doppelganger. That's Madame Mim from The Sword and the Stone, when Madame Mim becomes the dragon towards the end. So there she is. And now we also have for members, we also have the Madame Mim emoji, and it says, I'll allow it. Hopefully you can read the text. I have no idea what it looks like when it's emoji size, but hopefully you can read the text. But there it is. I mean, let's just look at the face though. Like when I saw this happen in real time, I was like, I know exactly what moment that is. That's this. That is this. So yeah. Couldn't agree with you more, DB. It kind of seemed like he invited them to file this. Yep. When you go back, and we did this at the beginning of the live stream, and you look at his order about preserving the records, right? And I intended to also go back to the hearing, and because I think he says something similar in the hearing. I just didn't have fucking time. But even if you just take the wording in the order, he's totally like, yeah, like this is, I mean, it's going to cost the taxpayers more money because it's going to get continued. That's basically what he says. So yeah, absolutely. And speaking of which, the plan here is to redirect into today's Karen Reed. However, I need to check and see. I believe that Runkle has Mark Betterow on, which would, I mean, I don't know. I'm kind of trying to think about how to do it. And I'll probably just let you guys decide what to do, because we could redirect into, like when we finish with this, we could redirect into that, because I didn't realize I could do that, but apparently I can, which would be awesome. Because that's going to be fucking amazing. And I don't think they've not ever been able to communicate. Like they've never talked before. And I'm sure it's going to be, I mean, y'all know how I feel about Runkle anyway. And then we could do, like, maybe when they're wrapping up, then we could do, the live stream with the testimony from today, or we could do that tomorrow because there's no court. So anyway, let me just go ahead and push it back though, because I had it set up not knowing how long. Okay, hold on. We'll just push it back here. So it's entirely possible that we could still redirect into Karen Reed, like here, and we could still potentially finish that testimony while Runkle and Mark Betterow are still going, because I wouldn't be surprised if they go for a really long time. That's what she said. So yeah, I wouldn't be surprised if they go on for a really long time. And, skipping through the sidebars and going and watching everything at speed, we could probably knock out that testimony from today pretty quickly. So, all right. Anywho's, welcome, Meg. Happy Annie says do that tomorrow. Okay. Needs some he's watching both. Love it. Multitasking. Check out the new emojis for anyone who's just now getting here. Thank you that's a great point also, DB. Thank you. In the motion change venue, Judge also cited the study from the defense expert that said heavy coverage closer to the trial and new media leaks is prejudicial and a cooling off period works. Yup. That's so funny, because that's what I was saying in my texts to Twiz, but I forgot that Judge DB, do you remember how long he said for cooling off period? I was texting Twiz about it, and my instinct was like 6 months. Like, that's what I was thinking. I was thinking 6 months. That just seems like that would be what you would need. But I wonder if it was actually, they gave a specific time. I would imagine probably did. If anyone wants to go looking for that. Okay, we'll do the Runkle then. We'll do the Runkle. And if you guys are up for it when they conclude, we could do, or we could do it tomorrow. That's all good. Okay. So yeah, because you all know how I love Runkle. Okay, so carrying on here. Higher burden on the defense, Again, an unparalleled life history investigation. This is kind of just like elaborating on the previous sort of grounds here. Compile it all into a cohesive narrative. Yup. What a constitutionally adequate investigation entails. Again, we're well aware. I mean, yeah, it is very extensive, isn't it? They're not kidding about that. But none of that is new, so we're going to keep going. Case law there. Takes time. Yup. Mental health experts. Yup. So in other words, they're saying like, well, we have to do this entirely, like thoroughly exhaustive review of the whole life history. And then only after that can we determine what additional experts are needed. I mean, they're right. Yeah, a full investigation is likely to lead to discovery of numerous mitigating factors that would not be readily apparent from a cursory investigation. I agree. But normally they would be like, just do your best or whatever. Again, I think that last Roman numeral number 5 is going to be the main thing here. So we're just going to keep going because a lot of this is just repeated. Analyzing each theme, childhood poverty. I don't know that that's really relevant here, but we're just talking about that. It is incumbent upon the defense team to investigate beyond the mere surface level identification of mitigation factors. Yup. Again, a full investigation. Yup. We know it's very important. This is interesting. Juries have rejected the death penalty in at least 400 cases involving multiple victims, demonstrating that the outcome of this case, even in the event of a conviction, is anything but a foregone conclusion. That's interesting to note, guys. What they're saying here is by having a comprehensive life history and mitigating circumstances, they were able to overcome the aggravating crimes, including cases with multiple victims. There's one such case, actually, I always forget the name of the dude, but it was in Texas, and it was a death penalty case. And he killed it was like a husband or an estranged husband or something like that, killed the mother and like the baby, right? So multiple victims, right? Mother and baby. The prosecution to me did the real slimy thing where they just really played upon the emotions and all that. And it was like really icky. But and he had public appointed, counsel, and they put on stellar expert witnesses during the sentencing phase. The defense's portion of the sentencing phase was maybe like a week or longer. And they had their experts were incredible. And again, multiple victims, including a baby. And sure enough, the jury said, nope, we're going to do life. They rejected the death penalty. So yeah. I wonder if I'll even mention it. Look at that. The list goes on. Okay, let's keep going. I'm going to open this. And again, we can save these for another live stream, but just to have those links. Counsel cannot identify all necessary experts. Oh, this is what I was literally just saying. Without completing comprehensive life history investigation. Yup. Genetic histories. That's ironic, isn't it? We're almost to Roman numeral 5, though. We're almost there. There are numerous examples of capital case reversals because counsel failed to complete the social history investigation, even when competent experts have been hired because the evaluations resulted in inaccurate and or incomplete information presented to the sentencer. Therefore, the investigation into the individual's life history must be completed before counsel can know the full spectrum of necessary experts for the penalty phase. Yep. Counsel has to have additional time to fulfill those requirements as described above, and we're moving right along to the main attraction here, as it were, feature presentation, which is life investigation needs additional time. Yep. Again, all of this would have been prepared already, right? But now we have the new part. A continuance is also necessary to investigate and remedy the prejudice of highly inflammatory publicity released just weeks before the current trial date, including the recent Dateline NBC special and a forthcoming book. This case has garnered substantial public interest, and the court previously issued a non-dissemination order restricting the release of certain information to the public in order to preserve the integrity of the proceedings and safeguard Mr. Kohberger's right to a fair trial. On May 9th, 2025, just weeks before this capital trial is set to begin, Dateline NBC aired a 2-hour episode about this case titled The Terrible Night on King Road. And again, you know they did this on purpose in proximity to trial, that's the whole thing. Like, they're going to do it in proximity to trial because that's when everybody's going to care about it. But you can see how it's just like insane, because when you look at like things that are going to be prejudicial, right? Like, oh, we want to drop this right before trial because everyone's going to be caring about it and talking about it. I was like, well, that's exactly why you shouldn't do that, right? I mean, they're allowed to, but that's exactly why it's problematic here, especially when it's in violation of a non-dissemination order, right? The program includes details and materials, including video footage, cell phone records, and photographs of documents that are not publicly available through official channels. The show repeatedly emphasizes the non-public nature of this information, stating it was obtained from unnamed sources who are close to the investigation, and that the materials were obtained exclusively by Dateline. They do say that a bunch of times, exclusively by Dateline. Much of the, quote, investigative, end quote, material presented by Dateline was taken out of context and will not be admissible at trial because it lacks reliability. Yeah, and I literally said that. I was like, yeah, a lot of it is just dumbness. The leaked materials appear carefully curated to promote a narrative of guilt. Yeah, I mean, that's what they're going to do. As this court acknowledged in its May 15th, 2025 document and records hold order, the source of the leak, and I love it, right? As this court acknowledged, again, it's like, Judge Hippler, we agree with you. This is the state's fault, and this is going to cause problems. So as the court acknowledged in its May 15th, 2025 document and records hold order, the source of leak is most likely someone currently or formerly associated with law enforcement or the prosecution team. If that is the case, it raises urgent and serious questions about the objectivity, judgment, and credibility of the individuals tasked with investigating and presenting the state's evidence, particularly those who may be called as witnesses. The identity of those involved, their motives, and any efforts to conceal their conduct go directly to the heart of witness credibility and the integrity of the state's case. The apparent leak is not only an egregious violation of the court's non-dissemination order, which they hate, they being the courts, it enabled Dateline to gild rampant speculation with a veneer of credibility. When purportedly, quote, exclusive, end quote, information surfaces through a media broadcast shortly before trial, particularly information attributed to unnamed sources with access to the investigation, it carries a heightened aura of credibility and secrecy that can deeply influence public perception. Yeah, definitely true. Unlike official disclosures, which are typically accompanied by context and procedural safeguards, leaks framed as exclusives are perceived as uncensored truths that the public was not meant to see. That's a great point, too. People want to see it even more, right? This insider framing enhances the material's persuasive power. Yeah, suggesting that it is both authentic and revealing of the case's hidden realities. Well said. Well said. The episode includes things such as repeated speculative assertions regarding the assailant's motives, including unfounded allegations of sexual motivation. I'm just remembering now, there's even a part where they talk about like having some sort of communication with the victims on social media prior to the you know what I mean? Like, what is it? Like a relation on social media, or did anybody watch it and see that? Because I didn't watch the whole thing. I was just, as y'all know, looking for certain things, but some of this I heard as I was trying to fast forward through the commercials. And like, I remember them saying something about like, they're trying to suggest that he was following them on social media. And I'm like, literally, you gotta be kidding me, because that has like on the record for a long ass time now. It has been stated by everybody that they found no connection. So like, what the actual fuck? Anyway. Dramatic reenactments and animations depicting the alleged crime created by the show's producers without basis in the evidentiary record. Emotional interviews with individuals connected to the alleged victims, accompanied by evocative music, photos, and videos designed to elicit strong emotional responses. The broadcast repeatedly bolstered its speculative claims through the use of so-called expert commentary, including individuals identified as law enforcement professionals and academics. And it was really funny because they definitely dressed these people up as well and put them in a certain like background and tried to make it look all funny. Not funny. Try to make it look, I don't know. It's funny when you are used to just the actual legit like hearings, court documents, trial, and then you see something like that where it's like the music and the narrative and all this, and it's just like so silly seeming, right? These commentators were permitted to make sweeping assertions about the defendant's alleged motives, psychological state, and personal history, none of which are grounded in evidence before the court. While the program repeatedly emphasized their training, research, and years of experience to lend undue credibility to their conjecture. This type of testimonial mimicry improperly mirrors expert witness testimony in a trial. Another great point. That's another great point. That's such a great training, research, and years of experience. Yeah, what a great point. To mimic expert witness testimony in a trial setting without the safeguard of cross-examination or evidentiary standards, effectively presenting the public with a one-sided, unvetted narrative that shapes juror perception for any admissible evidence has been presented. Yep. While the program occasionally inserts disclaimers such as, "We don't know what happened," these brief caveats do little to mitigate the cumulative impact of an extended narrative constructed through selective imagery, emotionally charged reenactments, and detailed speculative descriptions of the crime. When viewers are presented with a cohesive, visually reinforced sequence of events, especially when paired with commentary from individuals styled as experts, the overall presentation fosters a sense of authenticity and truthfulness that is difficult for viewers to disregard. An occasional passing verbal disclaimer functions more as a legal formality than a meaningful check on prejudicial perception, and most viewers will leave with the impression that they have seen a reliable reconstruction of events. This is very well said, and I couldn't agree more. They're making even more excellent points than what were immediately obvious, because there's so many points to be made here. But yeah, this is great. The Dateline special, which aired just weeks before the trial date, will not even be the last pre-trial media, quote, bombshell, end quote. Best-selling crime author James Patterson has written, James Patterson, do y'all know him? Has written a book about the murders titled The Idaho 4, An American Tragedy, scheduled for release on July 14th. Of course, just 16 days before jury selection. Like I said, it's the proximity, right? So all about that proximity. There's a reason they do it that way. And I guess you can see it on Amazon. I'm curious what the cover looks like and stuff. By the way, I just set it up to redirect us when we're finished here over into Runkle. So that will be awesome. Again, for anyone who didn't hear, he's got Mark Betterow on, as if he couldn't get any more awesome. So let's take a look. There's the book. Take a look. It's in a book. American Tragedy. Anyway. Oh, God, I hate it already. We know what it's like to live in Moscow on Idaho, November 13th, 2022, the day of the cold-blooded killings. We know what the local police and FBI did right and what they did wrong. We have the backstory for Bryan Kohberger, brilliant grad student, loner, apparent incel, and now indicted and facing trial. Now you are the jury. The evidence is in. Oh, my God. We could do a whole live stream with just the issues already here and how disgusted that makes me. So I'm going to table that. We'll save that for another day. Wow. Okay. Again, I've got all these other hyperlinks I've opened up. That might be a good time to read that and fully and get mad at it. And also just talk about how it violates everything. The blurb for the book describes Mr. Kohberger as a brilliant grad student, loner, apparent incel, and explicitly tells the reader, now, literally, you're the jury, the evidence is in. So they were pissed at that like I was. The publisher boasts of unmatched access to the investigation, including interviews with local law enforcement. Fucking hell. This suggests that the apparent Dateline leak was not the only violation of this court's non-dissemination order. Wow. Twiz is asking when I'm doing Karen Read. Well, initially, I was going to redirect this into Karen Read, but the chat had spoken and said that they want to redirect into Runkle because Runkle has better on. So depending on how long they go, I could do Karen Read after they wrap up, or we could do it tomorrow. I still could redirect. I mean, there were a number of people that were like, yeah, redirect into Runkle for obvious reasons, right? And again, we could always go and do that live after they finish. So, and I haven't even seen what you guys are saying in the chat. Let's just see here. Very true there as well, DB. My singing is the main attraction. Wait, my singing is the main attraction for what now? I have no idea what that's from because that was from 10 minutes ago. My singing is the main attraction. What is that in reference to? Or as Lolly would say, with reference to? Yeah, the exclusive nature. I mean, she made a lot of good points. And the whole thing, I didn't even think about that. The whole thing of like mirroring expert witness testimony was a great point as well. Well, and the other thing too is that it's law enforcement, right? It's law enforcement. That's what Judge Hippler said. That's what Dateline said. And apparently that's also what this author says. They talk about from law enforcement. You know what I mean? I got the impression from the parts that I saw in the Dateline thing that it was like FBI, but I mean, they don't say specifically. That's just the impression I got. That's funny, DB. Oh, that's funny. That the Dateline section was the main attraction. Okay. Are you talking about my silly singing? I mean, there's just so much. I don't even realize when I do it because it's just like automatic. Like, anyway. Okay. So, yes, this suggests that the apparent Dateline leak was not the only violation of this court's non-dissemination order. A continuance is necessary to fully investigate the leaks and to mitigate the prejudicial efforts of such inflammatory pretrial publicity occurring so close to the current trial date. Oh, again, did anyone, I may have missed it, did anyone go check and see what Judge or in the filings regarding the motion to change venue, if they gave a specific time frame that the studies show is sufficient? I'm really curious if it's, for some reason, 6 months seems like what it would be, but I'm really curious if anybody knows that, or maybe it was already in the chat and I didn't see it because I'm reading documents. But again, thank you to DB for refreshing our recollections collectively that was mentioned that the evidence supports that a cooling off period actually does help. So, So in Shepard v. Maxwell, the Supreme Court held that a defendant was denied a fair trial due to massive, pervasive, and prejudicial publicity that the trial court failed to mitigate. The court explicitly noted that a continuance may be required to protect the defendant's rights. Again, the harder they fight for a continuance, right? That's what they really, really, really want. The better they are going to be set up to make the argument, well, we really wanted this continuance because of the prejudice, but you know what? We'll settle for taking the death penalty off the table if that's the best you can do. You know what I mean? Like the art of negotiation, right? But where there is a reasonable likelihood that prejudicial news prior to trial will prevent a fair trial, the judge should continue the case until the threat abates or transfer it to another county not so permeated with publicity. Well, been there, done that part, right? The second part. The Supreme Court has likewise recognized that the passage of time, maybe they're going to say it, never mind. Passage of time can significantly reduce the taint of media exposure, right? That even in a case involving extensive coverage of a confession, the delay between media saturation and trial reduced its prejudicial impact. I'm sure in some of these they're going to give a length of time. Please be in this document. That would be just amazing. Pretrial publicity. Oh, this is from 1962. So Twiz, this is actually to one of the things we were texting about, and you were saying, like, how would it make a difference? And That's what they're addressing here, right? Pre-trial publicity did not impair juror impartiality, where by the time of trial, the news value of the original disclosures was diminished, and the newspaper items were often relegated to the inner pages. The thing is, guys, is that the general masses have a really short memory, right? They see the new thing, like what Ann Taylor said, the new secret, insider, never before released, exclusive, right? People that maybe didn't even care about this case or follow it, they're going to hear those buzzwords and the freaking music and whatnot, which I hate that shit. And they're going to be like, oh, blah, 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 right? But give it a period of time, maybe 6 months has been my guess. And they're not even going to, a lot of people will have moved on, right? They'll have moved right on. Because people tend to not be so smart all the time with the general masses, right? They just have it's a short attention span, right? Then they're just going to look at whatever's the newest thing, you know? So the court has recognized that while pretrial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial, the trial judge has a major responsibility. The measures a judge takes or fails to take to mitigate the effects of pretrial publicity may well determine whether the defendant receives a trial consistent with the requirements of due process. Love those two words, due process, right there. The timing of the trial is a key factor in ensuring juror impartiality, as emotional intensity and memory of prejudicial material tend to fade over time. Yep. And that's the other thing. It's not just memory of the material, but the emotional intensity. And again, going back to the whole thing where they do the crazy shots and the music and the narrative and all that bullshit that they have in these documentaries, it's to stir up emotions, right? So not only would you be, if it's recent in time, not only would you be remembering the facts or the information that you learned, but when you picture those images, you know, it's a subconscious thing. It's going to automatically stir up those emotions, even though it's all complete and utter bullshit. It's just like brainwashing people into feeling. I just hate that shit, man. Social science research supports this position. A comprehensive meta-analysis found that pretrial publicity significantly increases the likelihood of conviction, but that the effect is diminished when there is a temporal delay. How long? How long? Temporal delay between media exposure and trial. I mean, I'm sure it depends, but I'm just so curious if 6 months is the right amount of time. In sum, the 2-hour Dateline episode is uniquely prejudicial in both tone and content. It constructs a speculative narrative around motive and guilt, features emotionally manipulative, right? Disgusting, right? Emotionally manipulative production elements, and amplifies unsupported theories through self-styled, quote unquote, expert commentary, all timed to air just weeks before trial, when juror impressions are most vulnerable and voir dire least equipped to neutralize such deep-seated bias. The forthcoming book by James Patterson, which will arrive in the hands of potential jurors just 2 weeks before voir dire begins, it's like, have you no code of ethics? I mean, clearly not. Clearly not. Like, it's disgusting. It's like capitalizing off of the impending trial completely at the expense of any type of due process. I can't even really fully think about it because I'll just be too mad. So I'm just gonna keep reading. Promises to set off a new round of inflammatory negative coverage and to deepen the pervasive bias against Mr. Kohberger on the eve of trial. The court has already acknowledged that the Dateline special exposes a likely violation of the non-dissemination order, and Mr. Patterson's purported, quote unquote, unmatched access to sources, including local law enforcement, suggests that multiple unauthorized disclosures have occurred. Depending on the results of the investigation and the full extent of the misconduct revealed, the violations could, oh my God, say it. Sorry. The violations could warrant remedies more serious than delay. Your Honor, we'll settle for a dismissal. Let's just drop all these charges. And then he's like, well, that's a bit extreme. Okay, fine. We'll settle for dropping the death penalty. Dude, this is their time. This is their time, man. Dude. At the very least, however, a continuance is essential to allow the extremely prejudicial impact to partially subside, and to give the court and the defense time to fully investigate and address the scope of the violation. Wow, this is brilliant. Here's why. They're not already asking for it. They're not saying what sanctions they're asking for yet. Wow. If you're the state, you've got to be terrified. It's almost worse. It's almost like the suggestion of what could be coming, and it's like they didn't spell it out. But also, it definitely is like, look, we're being fair. We're not going to jump to any conclusions. We're going to give everyone time to address it, to look into just how deep this goes, just how bad it is. And we're not jumping the gun. We're not going ahead and asking for the moon, right? Oh my God. It's like we're being respectful and polite. We're being patient. We're going to let this play out, and then we're going to shoot for the moon. That's me. That's me paraphrasing, basically. Wow. Give the court and the defense time to fully investigate and address the scope of the violations. Holy shit. Only then can the conditions necessary for selecting an impartial jury and ensuring a fair trial under the 6th and 14th Amendments be meaningfully restored. I mean, this right here, literally, I was texting again. He was such a good sport. I was like, when I just saw that this was on the case summary, it hadn't come up yet, but I was like, oh my God, this isn't me. My brain was like, holy shit, this is their chance. This is their chance. This is what's going to happen. And right there. So I was getting really excited and really squirrely. Okay. Reversal is more likely than not in any case resulting in death sentence. Now we're back to kind of your par for the course, grounds here. A frequent cause is reversal on ineffectiveness grounds to the lack of an invested. So they found here in a 23-year study, reversible error was found in 68% of the cases. Wow. Hundreds of cases could serve of examples, but for brevity, the following are, federal habeas. The following are, well, let's see what it says. Examples from the United States Supreme Court and the Ninth Circuit courts that will have jurisdiction over the review of this case. Oh shit. It's like, here's what could be in your future, Judge Hippler, because this is actually the right jurisdiction that will be assessing this. And there's a footnote. Cases resulting in the death penalty undergo a unique, extensive appellate process. Yeah, we know. 5, 10, 20 years in the future. Yup. So all these cases here. Ninth Circuit. Wow. Mr. Kohberger deserves a fair trial from the outset to prevent an arbitrary or wrongful conviction and potential death sentence. These cases underscore the critical importance of thorough investigation before trial. This diligence is essential to avoid the costly and time-consuming process of reversing a conviction and death sentence years or even decades later. A continuance is reasonable and necessary under the circumstances. I think this is their last paragraph here. While there is no mechanical test for determining whether a continuance should be granted, a trial court cannot deny a continuance based on, quote, a myopic insistence upon expeditiousness in the face of a justifiable request for a delay. In determining whether denial of a continuance request resulted in violation of due process, the reviewing court looks to the circumstances of the case, particularly the reasons presented to the trial judge at the time the request was denied. This request is not made lightly. Oh my God. Literally. One more time for the record. Welcome, Franks. One more time for the record. Here's what I said to Twiz. When I was before this document came out, when I was getting all squirrely, like I said, and texting like a whole thing, and I was getting all excited, and I was like, oh my God. I'm going to read it one more time, the text that I sent him as my sample of what I would say if I was the defense. I'm reading this verbatim. If I were them being the defense, I would ask for sanctions because what they could say is, quote, this is me quoting myself, Your Honor, Your Honor, we were ready for trial, and we don't want to continue this trial. But now we have no choice. And now, due to no fault of our own, and because of actions taken by others, and in violation of Your Honor's order, Bryan Kohberger is unduly prejudiced and having to remain in custody pending trial. And with every day that he's having to remain in custody past that trial date, right? That's just yet another violation of due process. And that was like my little synopsis of what I would say, because it's like, look, we didn't want to continue it, but now we don't have a choice. And see, the more you go with that, then that's when it makes taking the death penalty off the table, like, well, the defense is willing to compromise with that, right? You see what I mean? So that's what they're saying. Defense counsel has worked around the clock actively preparing for trial since appointment to this case, filed all motions in a timely manner, complied with expert disclosure deadlines, and had expected to proceed on schedule. However, it has become clear that without additional time, the defense cannot complete review of the necessary discovery, meaningfully respond to all of the state's amended expert disclosures, and incorporate the information into an effective defense, and finish critical sentencing phase investigations. While prompt administration of justice is important to both the state and Mr. Kohberger, the constitutional guarantee of a fair trial outweighs modest delay. And because the majority of cases ending in the death penalty are later overturned for error, the public interest lies in ensuring a fair trial in the first instance. A continuance will ensure that Mr. Kohberger's fundamental constitutional rights are honored and that any verdict rendered rests on a fair and complete presentation of the facts, not on forced haste. My absolute favorite part is this part. Where'd it go? I think it was before all this. Twiz, are you still here? Because if so, I was going to say something here. Right here. This is my favorite part. Once the source or sources, plural, of the leaks are identified and the full extent of misconduct revealed, the violations could warrant remedies more serious than delay. I mean, this is their chance. This is their fucking chance. Time is everything in this case. And then I love how they follow that up with, look, we're not jumping to any conclusions. We want this to be fully investigated. Let the state think about their behavior. It's like putting them in timeout. Let the state think about what they've done. And you better believe that Judge Hippler is going to make sure the state knows just how disappointed he is as well in them, right? Wow. Wow, wow. Is Nightbot doing that thing again? Oh my God, Nightbot is so temperamental. It's really funny with Franks' command. Okay, Twiz is still here. Okay, one last thing, and then we're going to redirect over into Runkle. And again, what we will probably do is when Runkle's done, we might go ahead and do our coverage of Karen Reed from today after that, just depending on how long they go. I just want to do one quick other little thing. So Twiz had asked me a question here, and I'm going to read it because I couldn't possibly have texted back about it, but it's a good question. So Twiz said, what if it was a bad person, though? So basically, what I was saying is like, imagine if you're a defense attorney, right? And it's so rare for death penalty to be taken off the table. But imagine that you were able to do that ahead of trial, right? That death penalty is taken off the table. You would know as the defense attorney that regardless of what happens, if there's a conviction or not, you've just saved a person's life. And what I was said to Twiz, like, I was like, if I was a defense attorney, my entire life would have been like worth living for that, right? It's like, that is like everything that you've done was worth it, right? Even if that just happens once. But for most people, for most attorneys, that they're never going to see that day. And then Twiz said that would be cool if they took the DP off, but what if it was a bad person though? And then I was confused. So I was like, I don't understand. Is this a rhetorical question? And then he said, if it was a terrible person, would you still want it removed? So Twiz, feel free to elaborate. But I wasn't sure if you were like joking or, I mean, essentially, are you asking the question of like, if it's a horrible person, would I feel differently or should one feel differently? Or like, can you flesh that out a little bit for me? Because, I mean, what I will say just right off the bat, right? If you're a defense attorney, your job, your duty to your client is to get the best possible outcome for the client. So if they're only being charged with some sort of offense where there's maybe 5 years on the table, you know, if you can't get the charges thrown out, then you want to get them reduced. And if you can't get them reduced, maybe you want to try to go for a plea deal, right? And if you can, you know, if that doesn't work out, you know, or then reduce the time, right? It's like whatever the thing you want to achieve the best possible outcome for the client. That's the job. It's not based on who the client is. That's like not a factor. So like if you've got a death penalty case, right? Again, you're going to try to get the indictment dismissed first, right? Or the charges dismissed first, right? Then they're done that. You know, then you're going to try to like, you're chipping away, as we've seen in this case, right? We've seen it, right? But like the last best thing you can do before trial, no matter what, is to at least save that client's life in the event that they're convicted, right? So I don't know if that answers your question at all, Twiz. But you know, to say that, so what if somebody's a bad person or a terrible person? Like, first of all, that's subjective, and how would somebody judge that? But second of all, even if you could set a standard for that, which you can't, it's not at all even a part of the equation. Like, it's not a factor, right? You know, like, take people like, okay, take somebody like Stephen Stearns. I don't know. I don't want to, you know, there's certain criminal defendants who have done certain things that will always probably for most people feel like the worst of the worst crimes, right? And actually that's a death penalty case as well in Florida, right? Especially when it's things that involve like child things, right? Murder and child things. That type of thing tends to be like more emotionally charged, I guess, even than just like a regular murder. I mean, I don't know. It's all awful, right? We know that. But like, let's just say that you've got a case where, and I don't know what the evidence is. I'm not up on Stephen Stearns, but let's take it for example. Let's say you've got a criminal defendant where they've done all the bad things, killed people, done bad things to children, like literally just all the bad things, and that they've got it on camera, like they've got direct evidence, right? Like all of the evidence is like, there's really not a question that it was them. And if you're the defense attorney, then you're looking at a defendant who it's like, they definitely did these things, and these things are the worst things a person can do, etc. Right? You set all that aside because your job is to get the best possible outcome for your client. And the reason why that is the job is because only when a defense attorney does that, even for the worst of the worst, quote unquote, can it ensure that the government, the state, whichever, you know, whoever's prosecuting a case, that they are held to their burden. If you don't put them through their paces, they won't do the work, right? So you have to, in other words, it's almost like you would want to, if anything, treat every criminal defendant, if you're a defense attorney, like they are the best possible person, right? But again, that judgment doesn't weigh into it because all it's about is protecting their rights. And what all these criminal defense attorneys that I respect and admire say, right, is when people ask them something like, do you think the person's guilty? Or what if you know they're guilty, or things like that? Like, how do you handle it if you think they did it, or if you know they did it, or whatever, right? And it's like, that is not part of it, right? I think that Andrea Burkhart said, you know, my job is not to just, you know, to determine whether somebody's guilty or not. My job is to ensure that their due process rights are protected. You know, and in fact, additionally, with all the defense attorneys that I respect, admire, they all will say they never ask. They just don't ask. They do not ask. They don't ask, did you do it? And if somebody starts trying to like open their mouth about, they're like, stop. You know what I mean? Because that's not even relevant in representing them. It's not relevant, you know? It's not like only if somebody really believes the client is innocent, or maybe they're on the fence 50-50, that they should get better representation than somebody else who there's really serious damning evidence that they definitely did the things, if that makes sense. So hopefully that helps with answering that question. What we're going to do on the next Bryan Kohberger live stream, like I said, we're going to do a follow-up for this non-dissemination order. We're going to watch, hopefully, Twiz's interview, because he's famous. We're going to look at some other clips that I have saved. We'll also probably take a look at these hyperlinks. I have a number of things planned that we will do with that. And there could also be some more filings as well popping out here, given that they had a hearing today, and today's only Wednesday. So, of course, we will always stay apprised of that. But for now, love you guys, Squirrel Crew. We are going to, fingers crossed it should work. It should redirect us into Runkle. If that doesn't work somehow, then y'all know how to get over there manually if you want to. And again, depending on how long we go, we might do Karen Read after they finish, but this will be pretty cool if it works, right? Like showing up at Runkle stream, Squirrel Crew's here, woo! Anyway, but that'll be it for this one, guys. I love y'all. And I'll hopefully see you guys over there at Runkle with special guest Mark Betterow. But for now, squirrel out.